Okay, by my clock, it's 5 o'clock. So I'd like to call the meeting of the Town of Tremont Board of Appeals to order. We'll start with a roll call. Please state your name and your town. I'm Joanna Harris, Bass Harbor. Mike?
Bill Atherton, Bass Harbor.
Mike Hayes, Bass Harbor.
Richard Cohen, Seal Cove.
Marcia? You're on mute. Marcia Madeira, if you can hear me,
Okay,
there you go. You want to state your name and your town.
Marcia Madeira, Bernard.
Great, thank you all. I have determined that we have a quorum. So next, I'm going to ask if there are any adjustments to the agenda.
This is Mike Hayes. I have an engagement this evening that I'd very much like to attend, so that I move that the discussion concerning the amendments to the Board of Appeals ordinance be postponed.
I have a motion to postpone that item of business. Do I have a second?
Second.
Thank you. Everybody on the board who's in favor, please say aye.
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 Anybody opposed? Thank you. All right, Mike, we will honor that and move that to our next scheduled meeting.
Thank you.
Thank you. Have all of the members of the board had a chance to read the minutes from our meeting of December 9th?
Yes.
If so, I'll entertain a motion to accept.
I move we accept the minutes for December 9th meeting.
Thank you.
As
Do I have a
written.
second?
Second,
Thank you, Marcia. Well, actually, you weren't there, so I need a second from somebody who was there.
Second.
what?
Thank you, Rick. Any corrections, anything anybody needs to say before I ask for a vote? Hearing nothing, all those in favor of accepting the meeting minutes from December 9th, please say aye.
Aye.
Aye. Anybody opposed? Thank you. Okay, so our order of business tonight is to look at an administrative appeal by the concerned Tremont residents on the code enforcement officer's August 8th, 2020 and July 29, 2021 decisions authorizing changes to 11 structures at the Acadia Wilderness Lodge, 38 Kellytown Road, tax map 005, lot 102.
Madam Chairman,
Yes, Mike.
I move to deny a hearing of the administrative appeal from the concerned Tremont residents on the basis that their request exceeded the time limit to file appeals.
Okay, I have a motion. Do I have a second?
I'll
I
second that.
that.
All right, I've had a couple of seconds. Any discussion? Yes, James.
Chair, I wonder if, I don't want to bring this up, but it's been mentioned to me by Mr. P. Andrew Hamilton of Russell County that you might have a potential bias issue, and I wonder if you want to poll your board, even on the vote of the timeliness, which is of course a preliminary matter, as to which of the board members should vote on this. In other words, ask them if anybody has a conflict of interest prior to the vote, even on this preliminary matter.
And if I may be heard at some point, Chair Harris, that would be helpful.
Let me make a suggestion, Joanne. Why don't we dispose of the motion to dismiss the appeal, which I understand the appellant agrees is a necessary step and will not argue about that. Recognizing the fact that any objection that is had to my continuing participation will not be waived by that. So we could just get this short business out of order and out of the way. And if the chair wants to entertain the other application after that, we can do that.
I would maintain, Madam Chairman, that if we move to accept this motion, then the concerns about prejudice are a moot point, since we're not considering any of the appeals at this point.
Yeah.
They can be raised at some other date if appeals come back to this board, but there's absolutely no reason to do this if we are not hearing the appeal tonight.
I understand the design of the two members that have commented, but your Board of Appeals ordinance makes clear that you have to determine whether there's a quorum. And as part of determining whether there's a quorum, you have to determine whether there are conflicts. And so this is preliminary. It's even before jurisdictional matters. And that's the way it's stated in your ordinance. If you look to page 5 of your Board of Appeals ordinance, it says the chair calls the hearing to order, and the next thing the chair has to determine is whether there's a quorum. And then there's another provision of your Board of Appeals ordinance that says, as part of determining quorum, you have to determine whether there are conflicts. And I'm happy to walk you through that. But this is very preliminary.
I appreciate that very much. So, Madam Chairman, if we were to ask Mr. Cohen to recuse himself, would we still not have a quorum?
We would still have a quorum.
I would then ask Mr. Cohen to recuse himself from this conversation.
That sounds sensible to me. Mr. Collier, is that going to create a problem?
Yeah, I think that, properly speaking, back to somebody's point, I forget who it was, the better thing here, the cleaner thing, is to withdraw the motion, ask for a conflict, talk to Mr. Cohen, then make the motion again, just to be clean. By the way, I agree with Andy.
I have a point of order. I might need some help going through our ordinance here. So I'm looking at page 5D. It says I call the meeting to order, which I've done. Determine there's a quorum, which I've done. I give a statement, and I did not read all the correspondence. We wouldn't live long enough for all of that, frankly. Then I determine whether or not we have jurisdiction, and that's what Mike raised. I don't see where the conflict of interest is in the order of business in the ordinance that I'm holding.
So if I could, Madam Chair, because I think you're thinking through this well, I just want to do it alongside you. Section 7D, voting. It says if a member has a conflict of interest, said member shall not be counted by the board in establishing the quorum for such matter. In matters related to conflict, which is another provision, section 5, if you look to it, the member who has the conflict can't.
Mr. Hamilton, what page specifically of the ordinance are you on?
So let's first go to page 4, which is section 7D. If a member has a conflict of interest, said member shall not be counted by the board in establishing the quorum for such matter. As you pointed out, Madam Chair, quorum is one of the first things the board has to do. You were so quick in determining a quorum, I didn't have the chance to address you. So I want to have that opportunity and just make sure that the board understands there's nothing personal between me and Mr. Cohen. I'm sure he's a fine gentleman, but his statements make clear that he has a conflict because he has bias. And the law court has been very clear on this. And so then if you go over to section 4B, 4B on page 3 gets you to, yes, 4B on page 3. Where are the, there it is. Page 3 says the following. Maybe on page 2, 1 second. Yeah, it is on page 2. I apologize, Madam Chair. It says any question of whether a particular issue involves a conflict of interest sufficient to disqualify a member from voting thereon shall be decided by a majority vote of the members, except the member whose potential conflict is under consideration. The reason I believe Attorney Collier gave you correct guidance is Member Cohen actually raised his hand to second the motion to determine that the board does not have jurisdiction based on timeliness. And whereas I want to be efficient, I don't want the board to have a member serving that has a conflict such that we've got to play ping pong between the court back to the Board of Appeals, because as in Pelkey versus City of Presque Isle, when an opponent appeared before the planning board and then tried to serve on the board, which is the facts we have here, the court remanded to say the appellee was entitled to another hearing before a Board of Appeals that was without the member that had the conflict. So I think we need to straighten this out for the very first appeal and have it carry through for all AWL appeals. Thank you.
Let me ask a question.
Certainly.
Mike, how long do you have before you have to leave? I want to know how much time.
I'm going to stay here till hell freezes over, but I just like to say goodbye to a friend who's leaving the island sometime tonight. I don't care. I'll withdraw my motion and we'll vote on your conflict of interest.
Okay,
If that's the way it's going to play out, then that's the way we should play it.
Madam
Whichever
Chair,
way gets it done, let's get it done.
Okay, thank you.
All right, Mike, are you,
I'm prepared to withdraw my motion, Madam Chairman.
thank you.
Madam Chair, can I,
Yes,
On
I apologize. I don't know how to pronounce your last name.
it's pronounced Chow.
Chow, all right.
And I'd like to introduce myself to the board. I'm Amy Chow from the law firm of Drummond Woodson, and I do represent the concerned Tremont residents, or CTR. As we're dealing with these procedural issues, and you may decide to go a different way, but I would like to suggest an efficient way to address this issue now, because this is a procedural issue, and if there is a conflict of interest and the board is looking at jurisdictional issues and whether or not this is an untimely appeal, I think, I don't think I'm overstating it by saying that both the appellant, that's us, and AWL, represented by Andy Hamilton, agree that you need to make a determination about timeliness of your appeal, and that we do believe that it is untimely. It is essentially a procedural hoop that this board needs to go through so that we can go to court and address whether or not the good cause exception should apply. And I'm not going to get into that tonight because I want to be respectful of everyone's time. But I would suggest that an appropriate way to deal with this is if you have a quorum, which I believe is 3 members, and I believe you have a quorum present, even if Mr. Cohen were to vote on the issue of timeliness, depending on how that vote comes out, it's very likely that you would be able to address that issue, and we wouldn't have to address a conflict of interest issue that we're not sure we're ever going to have, and you won't have unless and until this comes back to you after a court makes a ruling. So I would suggest that you could take a vote on the jurisdictional issue now without getting into the conflict of interest issue, because you do have a quorum.
Thank you.
I think
So as to
you may be
that,
able to save some time here. Wait a minute, Mr. Hamilton. The danger of my doing something biased on a procedural motion that all the parties agree on seems to me to be rather small, but if it's a problem, let's solve it. Perhaps you could ask for a quorum again. I will not turn my computer off, but I will sit silently. You can have the vote on the dismissal of the appeal. And after that, I suppose, though I don't know if Mr. Collier would agree, you could call for a quorum again, and this time I could pop up and we could talk about the conflict business. Let's just get it done in some practical way. I don't want this issue to fester for a long time for a selfish reason. If I'm going to be voting on AWL issues, I've got work to do. And if I'm not going to be voting on them, I don't want to waste my time doing the work.
I greatly respect what you just said, Mr. Cohen, and I'd be in the same position you were in. I would not want to be delving into either the first or the second appeal that's now pending. And so I'm very careful in the way I ever look at bias and conflict questions, but because Pelkey versus City of Presque Isle is so much on all fours with what we have for facts here, I think it's better for the board to vote, get it out of the way for both proceedings. And it does come in terms of precedence before even jurisdiction. If you look at your ordinance, you don't get down to jurisdiction until you're
I'm
down
sorry,
to item
Mr.
D.
Hamilton, we're not talking about the merits now. Why don't you let the chair rule?
Yes.
No, the board has to rule on a conflict question.
Right. We understand that, Mr. Hamilton. Thank you. So James, as our attorney, what is your recommendation? What do you think is the cleanest way to do this?
As I said before, and in disagreement with Mr. Cohen, he's here now, so let's not recognize he's here. But I think the appropriate thing is you've already withdrawn the motion, whoever made that, I think it was Michael, withdrew it. So you're now back to the start. And so you introduce the issue and say, agenda item, we're now going to turn to, which you have, right? You've gone to whatever the AWL #1 appeal. So that's the start. Then you say, does anyone have a conflict of interest? And presumably Mr. Cohen will say, yes, I do. And then you'll discuss it. And then Mr. Cohen, in every board I've been involved with, it's the person who thinks they have a conflict or does not have a conflict, their primary responsibility to say, yes, I have a conflict, or no, I don't have a conflict. If the person says, yes, I have a conflict, then the vote is easier. Then there's a motion by the other members of the board. But in every board I've been involved with for 20 some years, the primary responsibility is with the member. Regardless of what the member says, yes or no, I have a conflict or not, then there's a motion by one of the board members that Mr. Cohen does or does not have a conflict. It's just easier if he says, I have a conflict, then the vote's easier. Sometimes people say, yeah, I know I said those things, but I can be fair and impartial, and then you have to hash it out. Let's see what happens here.
Okay.
This is not going to be easy.
All right. So first order of business, I understand, Mike, you have withdrawn your motion.
That's correct.
All right. I have determined that we,
I'll withdraw my second.
no, thank you, Mel. Sorry about that. I have determined that all 5 members of the Board of Appeals are present. So I will now ask, is there any member who has a conflict of interest in this matter? I hear nothing.
So may I be heard, Madam Chair?
First, James.
Yeah, I was just going to say, to get in there ahead of Andy, which is not easy to get ahead of Andy. I think the place to go here is if somebody wants to say something, if they all want to talk, it's the appellant and then Mr. Hamilton. So unless Ms. Chow wants to talk first, you go to Andy and then others.
Okay, thank you. First of all, does any member of the board want to say anything? Okay.
I wonder if the attorneys would want to consider the facts before they make their arguments. The only way that I know of to deal with them is to have me and anybody else who wants to talk about the facts. But I mean, if they want to talk theoretically, they may. Seems bass backwards to me.
James, first James.
I think the first thing is that before Mr. Cohen, we get into that, someone has to say, hey, I think Richard's got a problem. So nobody's raised that yet.
Right.
Okay. Well, no member of the board has stated so. Do any of the interested parties, is that the way to put it, James?
Yeah, Amy, Ms. Chow first, then Mr. Hamilton, then anybody else.
Okay. Attorney Chow, do you have a problem with any member of the board hearing this case?
No, I do not. And if I could just be heard procedurally on just one point, I do think Mr. Cohen has a point here that rather than listen to the attorneys talk about the case law involving the case law and the statutes involving conflicts of interest, in addition to the fact that your own Board of Appeals ordinance has a definition of conflict of interest, which mirrors the statute, which is very specific. And it also speaks to the term prejudice. But rather than have us argue about cases and what the statutes mean, I might just suggest that the board may wish to hear from Mr. Cohen first, and then it may be appropriate for the attorneys to frame that within what each of the attorneys believes the law requires in an instance like this. But I do think it is putting the cart before the horse to have us argue law before we've heard from Mr. Cohen.
Well, first, I still don't have an objection to Mr. Cohen hearing this. Attorney Hamilton?
So I've been doing this for 35 years, and I think I've raised this question maybe twice in that time. And so, Mr. Cohen, to you in particular, I don't raise this mildly. And I did hear your clarification before the select board when a member of the public raised the question of whether you would have bias. And when I looked at Pelkey versus City of Presque Isle, which is controlling authority in Maine, it says you look to the statements of the individual and whether that individual has offered opposition. I know of no members of the board that either occupy the position of support or opposition that you occupy. And when you ring the bell, it's kind of hard to unring the bell. And there's one statement in particular that I've cited in the materials that causes me a deep concern with whether, even if you feel that you could be impartial, why the
Mr.
courts
Hamilton,
would agree with that. So,
I'm Mr. Hamilton,
yeah,
Mr.
go
Hamilton,
ahead.
I'm going to call a timeout because you have raised an objection. I think it would be only fair at this point to give Mr. Cohen a chance to say why he doesn't feel he has a conflict, and then you can absolutely take it on. So thank you for that.
Thank you.
Rick?
Yep. I spoke in opposition. I may have written a letter to the select board too. I forget. I know I thought about doing that, but I don't know whether I did. But I know I spoke up at a community meeting that the applicants raised and spoke in opposition to the original application, which I made clear I objected to principally for two reasons. Number one, too many units. There were like 154, something like that. And the presence of RV sites, I think 72 in number. I honestly don't know what the population of Tremont is, but I know if 154 additional campsites are occupied for a few months of the year, that will bump the population of town, I would guess, and it's only a guess, maybe 50%. And that would be quite a jolt. And I thought that was not such a good idea. And a bunch of these big RVs invading, I thought was a bad idea too. I was one of a number of people who spoke up at that Zoom meeting. And the reason for the meeting, I'm sure, was to get the community's reaction to the application as an entirely proper purpose. And I think that the applicant and their advisors, applicants and their advisors, heard the community, which was virtually unanimous, saying, hey, it's too big. And hey, we don't need those RVs cruising around that very hilly, twisty area of Route 102. Then I heard, I think before it actually happened, it had gotten around town that the application was going to be either amended or withdrawn. I don't want to get into that problem if it is one. And units for RVs eliminated altogether, good. And total campsites reduced from 154 to about 1/3 of that number, or 55, I guess. Good. And when I heard that, I took my road signs down that had said, if you want to be crowded, go to Bar Harbor. And I decided that this was a new ball game. And I don't know whether I was going to be in favor of it or not. And in candor, I still don't know. One of the things I said to the select board at the meeting when they were considering the second meeting when they were considering my appointment was that some people oppose my nomination because they think I'm anti-campground. Not anti-campground. I was anti that first application, as was almost everybody else in town. And the applicants had the good sense to withdraw it. The other thing I said was that opponents to the campground think I'm a safe bet to deny it. And they're wrong too. I don't have a dog in this fight. I spent 44 years either as a trial judge, an appellate judge, or an arbitrator. And I spent all of my time making sure that I did everything I could to fairly decide disputes, whether they were about land use, whether they were about whatever they were about. And I think I did that. And it is, I just think, outrageous at this point to think that I'm going to adopt a new approach to the law and a new approach to public affairs. I'm not. I don't have a conflict. I don't have a dog in the fight. And I'm sensitive to these things and have been all of my adult life. Now, Mr. Hamilton, I accept your assurance that there's nothing personal here. And I don't feel anything personal about it, but I just think you're dead wrong. I have a vague recollection of what you said about was it a trial court case that you think supports my recusal. There's nothing in that case about different applications and different things to consider. I don't know the Hopkins. I've got nothing against the Hopkins family. I think I've spoken enough, maybe more than enough. Thank you.
Thank you, Rick. All right, Mr. Hamilton, you want to respond?
So again, this is not easy for an attorney, particularly when addressing a gentleman who's been on the bench. But judges in particular know that you have to avoid even the appearance of impropriety. And that's part of the judicial canon. And my concern is, if you've read Pelkey versus City of Presque Isle, as I hope you have, because it was a Board of Appeals case that went up to the law court, and the Maine's highest court said what they said. But to just put this in the proper frame, in our letter, we had provided an extensive record of several statements, not just one, but several statements that were made, and those appear on page 2 of our letter of December 13, 2021. After Ms. Kenya Hopkins addressed neighbors, you spoke up and you said the following: you, addressed to the Hopkins, you will be constantly aware that this is a development that Tremont doesn't want, and for damn good reason. And if anybody else feels the same way on this call, maybe it's time to speak up. Again, that's but one of many statements. Others are reported on page 2 of our letter. And they didn't come from us. They came from Lincoln Milstein in his column, The Quiet Side Journal. And he reported on the statements that you had made. And it was pretty clear to us that you are opposed to the core of campgrounds. The reason I said earlier it's hard to unring the bell is because if you begin to develop a sense of partiality and prejudice towards a project, it's difficult to convince everyone that you've somehow become fair and impartial. I heard your statement before the select board where there was an effort by the CTR group to have you named a member of the Board of Appeals. And I heard what I heard about what CTR was saying in an effort to have you serve on the Board of Appeals. I'll take your representations at face value, but what I can't do is change the law in Maine. I'm not on the law court. I'm not a law court justice. The law court says that where you had an individual Board of Appeals member who ultimately served on the appeal board, was first a vocal opponent to Pelkey's application during the hearings that culminated in the planning board's original decision. The law court then looked to Pelkey's objection. He filed an objection to the findings of the Board of Appeals, claiming bias of one of its new members rendered the findings invalid and thus violated his right to due process. The law court then stated the record further discloses that prior to his appointment to the Board of Appeals, the new member had previously been a vocal opponent to Pelkey's application. The law court noted on these facts, it cannot be said that the Board of Appeals findings of fact and conclusions conform to the minimum requirements of due process. I don't care whether you're a lawyer, judge, doctor, merchant, chief. There is, I think, a requirement of due process that applies to both the planning board's review, and I note that members Beth Gott and Marjorie Buck, who are abutters, they didn't even have public statements in opposition to the project. They automatically got recused from the planning board. And that board made sure that it was a clean review. The law court stated, the record further discloses that prior to his appointment to the Board of Appeals, the new member had previously been a vocal opponent to Pelkey's application. On these facts, it cannot be said that the Board of Appeals findings conform to the minimum requirements of due process. The law court then directed a remand to the Board of Appeals observing this. Pelkey is entitled to a hearing de novo on his application before only those board members who, as then members of the public, did not oppose or support this project. It's impartiality both directions. And so I don't bring this lightly, but here's my concern. This first one is easy. The jurisdictional call has already been conceded by Ms. Chow. She's in a hurry to get to the Superior Court to try to tie up the first project in court. The second one has already been filed. And particularly on the second one, with as much time as has been invested by the Tremont Planning Board, I just want to make sure that the Tremont Board of Appeals can be impartial. And I don't want to have to go to Superior Court if there's a finding that's adverse to my client and say, there was a member of the board who spoke up as an opponent, same case as Pelkey. It's on all fours. And I appreciate the representations, Mr. Cohen, and I appreciate your historical experience, but it doesn't change the fact that you said what you said, and it was very public, and you were inviting opposition to the project. So I'm sorry to even bring this forward, but I'm compelled by my position on behalf of a client that's seeking to protect its property rights. I'll leave it there.
Thank you, Mr. Hamilton. Ms. Chow?
Yes, thank you, Madam Chair. I'd like to respond with a few points, but I want to start first of all with Pelkey versus the City of Presque Isle, and to make the point that that case is completely distinguishable from this case. And the reason that's so is that the facts in Pelkey involved a person who made statements in opposition of a project that then ultimately got approved on that application. And you've heard Mr. Cohen say, and everyone knows that, and I'm not getting into semantics about whether it's a new application or the same application, but there can be no dispute that the project that the applicants came to the planning board for ultimately is a far different project than the project that Mr. Cohen and the application that Mr. Cohen had opposed. And he has made that clear in his statements to the board tonight. So Pelkey is completely distinguishable because I would agree actually that if Mr. Cohen had opposed the project that ultimately the planning board did approve, it wouldn't serve CTR or anyone to have him participate and potentially taint those proceedings. That's not what I heard tonight. I don't think that's what the board heard tonight. And especially here tonight, you were here to decide whether a different campground proposal, one that borders Kellytown Road for 11 units, started out as 11 cabins, now it's 11 yurts. And that is a different proposal also. So you've heard from Mr. Cohen, he has said, I don't have a problem with the applicant. I have no issue with the applicant or with the family. And I've made no determination in candor about where he comes down on the application that was ultimately approved by the planning board, which is a different project than the one that he voiced concerns about as a citizen prior to his election on the board. So that's why Pelkey, I agree with Mr. Hamilton that Pelkey is good law. It's distinguishable on these facts. A couple more points I would like to make though, with respect to your own ordinance. The Board of Appeals ordinance defines conflict of interest very specifically as whether you have a direct or indirect pecuniary interest. And I won't go into all those definitions. I think the board has heard clearly from Mr. Cohen, and that simply does not exist here. The statute that deals with conflicts of interest is very specific to direct or indirect pecuniary interest. That's not alleged here. It is true that that statute does go on to say, and you should avoid the appearance of a conflict of interest. In other words, you should avoid the appearance of a conflict that would arise by way of this direct or indirect pecuniary interest. Again, not something that I think we are hearing here tonight. These facts do not apply at all as a conflict of interest. So what we are really, I think, what it really comes down to is this question of whether or not Mr. Cohen has impermissible bias, or under the terms of your own ordinance, your ordinance in section 4B on page 2 does talk about prejudice. It says prejudice that would prevent a board member from rendering a fair or impartial decision. Does Mr. Cohen have prejudice? And if this is something the board is going to vote on, which I think is procedurally what you need to do without Mr. Cohen, of course, voting, I think you need to look at whether the facts that he has alleged here amounts to prejudice or bias. And I would argue that allegations of bias, and I know they are, carefully drawn, but not all allegations of bias lead to a procedural due process violation. And it's up to the board to decide whether the facts that Mr. Cohen has presented amount to that bias or prejudice. And I certainly haven't heard anything that rises to the level of that. Thank you.
Thank you, Ms. Chow. Mike, you have your hand raised?
First, just a general comment. Whose meeting is this? It looks like it's a meeting for the attorneys about a subject that we're not even talking about. They are dealing with the new revised, whatever you want to call it, proposal for AWL. We're not dealing with that. That was what Mr. Hamilton alleges Mr. Cohen was opposed to. This is not that item. And I'm tired of lawyers coming in and deciding they can run roughshod over the citizens of this community. Furthermore, let me tell you that I was at the meeting with the Board of Selectmen when it was raised about his bias. He addressed it, and the Board of Selectmen, in their wisdom, said, "We believe you." All right, so I'm not prepared to substitute the attorney's opinions for the opinions of the Board of Selectmen in this town at this point. I propose that we move on and deal with the object at hand, which, as far as I can tell, no one disagrees with. No one disagrees that they are too late to come before the Board of Appeals. No one disagrees with that. I have one more thing to say, and I would like to ask Attorney Hamilton the following, and please be careful with your answer. Are the positions made public by a participant in a proposal sufficient in your mind to indicate the scope of their activities? Is what somebody says publicly what ultimately matters when you get down to, if you will, pardon my French, the short strokes?
So member Hayes, let me just answer respectfully.
Can I get in before Andy?
Sure, I'll pause, James.
Madam Chair, I
Yes.
wonder if Mr. Michael there would like to make that a motion that Mr. Cohen does or does not have a conflict, and then ask Andy.
Yeah, I move that we vote as to whether Member Cohen has a conflict of interest in this case.
Do you move that he has a conflict, or do you move that he doesn't have a conflict?
I move that he does not have a conflict of interest.
Do
Second,
I have a second to that motion?
second,
It's been moved and seconded that Mr. Cohen does not have conflict in this case. Rick, you cannot vote, but I'll call for a vote of the members of the Board of Appeals.
Move that it be a roll call vote.
Was that you, Mike?
Yes, I'm sorry.
Okay, yes, roll call vote. This will either be I agree he does not have a conflict, or no, I think he does. So Mike,
Aye.
Mel,
aye,
Marcia, you're on mute.
Now, am I on mute?
No, you're good now.
I don't think he has a conflict.
Thank you. And I also do not believe he has a conflict. So that is 4-0 in favor of the motion that Rick Cohen does not have a conflict in this case. Now, given that, we can now move on to whether this is a timely appeal. Is that right, James? Okay, thank you. So may I have a motion regarding that?
Yeah, yes, Madam Chair. I move to deny a hearing of the administrative appeal from the concerned Tremont residents on the basis that their request exceeded the time limit to file appeals.
Thank you, Mike. Do I have a second?
I second that.
Thank you, Mel. Any further discussion? Hearing none, I'm going to ask for a vote. I'll ask all those in favor, please say aye.
Aye.
Aye, including
Aye.
Rick. Thank you. Any opposed? Hearing none, the motion passes.
Madam Chair, I'm sorry, point of order.
Yes.
I believe the Freedom of Access Act, when you're having a Zoom remote participation hearing calls, asks for a roll call vote for
Okay.
that. Thank you.
I think you're
I would
right.
also, I would also need to speak up again, Madam Chair, not because I want this meeting to go a minute longer than it has, but because my client has property rights that I have to defend.
Let's
And
do the roll call vote first, please.
No, I need to be heard before the vote's taken. It won't be meaningful after the vote's taken. So
Andy,
if I
the
can,
vote, Andy, the vote
if I
was
can be
already,
authorized to speak, Madam Chair.
James,
Voted.
can I get some advice?
I don't know what Andy wants to talk about, but there's a motion on the floor. You called for comment. There was none. I
Not
think-
true. I have my hand up.
Oh, you were hit. I didn't see your hand, Andy.
I didn't
So if Mr. Hamilton's got a burning desire to say something before you vote, if he can make it brief, fine. I think all he wants to say is that he stands on his written submissions. And I've already argued with him on the phone about whether he needs to say that, but he thinks he needs to say that. So I'm hoping he can just say, I stand on my written submissions.
Mr. Hamilton, very briefly, please.
I'm sorry that attorneys have to speak up for property owners and clients. And I know that it's not popular, but I'm going to just say briefly, we do not feel this is a proper appeal, either as a matter of the merits or as a matter of timeliness. And the challenge that you're presenting to the applicant and here the appellee is that we are not even getting a chance to be heard by this board in a way that is fair, impartial, and complete. And I think you need to have a decision rationale for why you find that it's not timely, and you've given a court on review nothing to review. And that's exactly what Attorney Chow wants. She wants the judge to be able to conduct his own review. And I think it's not fair and appropriate to review by a Board of Appeals not to have any discussion. We're rushing because we're trying to get out the door, but it is not fair to the property owner. It's not me that needs to be able to talk. It's my client's got to be able to talk through me. So if you want to shut us down, you're making that very clear, but it's not making our life at all pleasant because we're facing a moratorium and we're facing endless appeals. And there's a conscious effort to try to get our client to stop based upon the expenditure of funds in the courts. And we're going right down an alleyway where a judge will have nothing to review as to your record. You're making a very quick decision without any discussion as to timeliness or anything about the merits of the appeal. And that's exactly what Attorney Chow wants. That's why she's conceded that she's brought an appeal that's untimely. Are you kidding me? An appeal has been brought and there's a concession that it's untimely. That means she really wants to get to court fast. That's not going to serve anybody well. And so I'm really concerned, Madam Chair, that you're not allowing a proper development of the case before you. I will say what Mr. Collier said I would say, and that is I have to stand on my written materials as to both the merits and the timeliness, but I'm very concerned. And if I don't speak up, we're gonna be accused of waiver of a number of claims we need to bring before the board. Otherwise, there's no exhaustion of administrative remedies. So if you want to shut me down, I understand, but don't do it prematurely unless you want to get us all involved in a very litigious proceeding, which is what this is becoming. We tried to get a good review before the planning board, get to a permit, but it's very clear Ms. Chow is here to tie this matter up in the courts or to shut it down altogether. And I've got to speak up because I've got a client who wants to be able to have an opportunity to act on permits that have been issued. And you're depriving us of that opportunity. So I'll be quiet, but I do so with great concern, grave concern.
Madam Chair, I know that you don't want to hear from attorneys and I risk incurring the ire of your board members, which I do not want to do. The only reason I am speaking up at this time is that Mr. Hamilton has spoken about what I intend or what I am doing or what my motivations are. Not once, not twice, but 3 times in his last statements. And I take great exception to his personalization of what this is. What you have before you is a Board of Appeals ordinance and a set of ordinances that has a 30-day appeal period. There has been no dispute that we are beyond 30 days since that the decisions that are being appealed, the decision of the CEO, the 2 decisions of the CEO, there is no dispute that 30 days has long passed. The good cause exception is a judicially recognized doctrine that only a court can invoke. So to cast this as a rush to anything, I take great exception to, and to suggest that you haven't done your due diligence in your vote tonight, which you actually did take, is just ridiculous. So I will stop, but I would encourage you to do your roll call vote. Thank you.
That there's actually great clarity in the law that there's a split of authority as to whether this is strictly judicial. But putting that aside, even we'll let the facts bear out what I've said. But I think the Board of Appeals should not be complicit in a litigation strategy, and that's what you've got going on here. And I saw a comment in the chat that only enhances my concern. Billable Andy at his best. I'm speaking up for the rights of a client, and I get hit with that type of claim. I mean, really. So I just would ask the chair for the opportunity to lay before you very succinctly why I don't think the merits are here. And I would like a decision, not just on timeliness, but on the merits of the appeal. It doesn't take very long. The appeal is very simple. But if you stand in the way, to me, that's further evidence that you really don't want to give a fair review of the property owner's position. Because Ms. Chow is very good, but I don't think it's appropriate to prevent the appellee, the property owner and the permit holder from having the opportunity to develop the case before you and then make a decision. And if you want to hurry it, that's fine. But that's what's going to happen.
Madam Chairman, he wants to have a hearing tonight, and we're incapable of having a hearing tonight. It is a clear excess in time before they filed. It's done. If we had a hearing here tonight, let me ask the attorney, if we had a hearing here tonight and we voted to uphold the appellants, you're not gonna take the town to court over that one? That's nonsense. You know we are here because it is too late. And that's all we're trying to say. It's too late to come to us. There are other venues and there are other remedies, and that's what you should pursue. So I don't understand why you want to have a hearing over something we frankly can't hear about. And this is just nonsense. Madam Chairman, please put a halt to this.
I really want to say on behalf of my board that we have heard plenty from both sides tonight. We are about ready to take a roll call. James, I'll give you a moment to say what's on your mind. You're muted. I can't hear you anyway.
I'm sorry. In reference to Michael's earlier comments at the start of the meeting, and thinking of what Andy said, I may have been remiss in making sure that Michael said, and if he did not, I want to know if everybody understands that Michael's comments are in regard to Section 8A, that I apologize, Michael, if you've already said this, that the appeals must be made within 30 days and that this is clearly beyond 30 days. Did you say that, Michael?
You're on mute, Michael.
Yes, I'm sorry. Yes, that was my main point.
Okay, I think we're ready for a vote.
We can't hear something that falls outside of that 30-day period. So all we're saying is we can't hear this. We have no jurisdiction here at this point because of the delay. That's the only thing I said.
Yeah, I just wanted to make sure that that section was noted. And I think you're ready for the vote.
Yeah, thank you for that. Thank you, James. That's the part of the ordinance that Mike is referencing. So for the record, that's the reason that we cannot hear this. It is too late according to our own ordinance, and we are obliged to follow our ordinance. So I'm going to call for a roll call vote. Can you remind me, please, Mike, what your motion was? It's been a little while.
I will read it again.
Okay.
I move to deny hearing of the administrative appeal from the concerned Tremont residents on the basis that their request exceeded the time limit to file appeals.
Thank you. And Mel, you still want a second?
I'll second that.
Thank you. All right, we have heard from everybody we're going to hear from. I'm going to do a roll call vote. I would be to support it. Nay would be to not support it. Mike?
Aye.
Mel?
Aye.
Marcia?
Aye.
Rick,
Aye.
and I vote aye. It's unanimous, 5-0. We will not be hearing this appeal. I understand from Jesse that we're not sure about our next meeting. There's some things happening. So I'm not going to set a date, but you certainly will be hearing from me once sort of the smoke clears. I want to thank everybody for being here tonight, and I can appreciate the motion and concern that everybody has on this. This Board of Appeals has a reputation for being very fair and following the law, and we have done that again tonight. Consequently, I want to thank you all. James, you have another word? You're muted. Can't hear you.
Sorry, I have a point on the other agenda item that you're not going to discuss. I just wonder if you want me to do anything about that. I mean, I looked at those things, but I don't think that, I think you have a pretty good thing now. So, in thinking of it, I think that it might be useful to me to tune into that meeting about changing the ordinance. But I don't think I should be asked to do a technical review. I kind of like it the way it is now, unless you think otherwise.
No, I'd prefer that you come in at that point.
Okay.
We're doing our own
Okay.
due diligence, and
Yeah.
Rick's done a fair amount of work, and I know Mike had some things he wanted to address. So once we're ready to have that discussion, then I think you should be part of it, James.
I think what I can most do is just tell you about, some of the other things in other places, they do it this way. But I think I like your ordinance. It's pretty good.
Okay, thank you. It needs some tweaking. It's been, what did we say, 16, 17 years since we've looked at it. So it's time. All right, I will entertain a motion.
Madam Chair, before you adjourn, I just wanted to say thank you to you for the courtesies extended, and to Mr. Cohen and to all members of the board. Best of the holidays to all of you. And I think we're going to try to give you at least more than a month break before the next appeal is heard, because the court reporters need to have full time to prepare the full record before the planning board. So best of the holidays to all of you. Thank you.
Thank you, Mr. Hamilton, and the same to all of you. I will entertain.
Say the same thing. Thank you very much to all board members for your time tonight, and happy holidays.
Thank you, Ms. Chow. All right,
Madam
I will
Chairman, I move to adjourn.
thank you, Mike. Do I have a second?
I second.
I don't think we need a roll call. I think it's unanimous. The board takes the prerogative to say it's unanimous. Thank you all very much, and happy holidays to everybody.
Happy holidays.
Thank you.
Thank you.
Bye.